Hi.
All
So
right.
this week we have David Streeter here with us, and I'm going to let Frank introduce him. And since he invited him, and you kind of take it over, Frank.
All right. Hey, today we got David Streeter from Streeter Petropolius. David is an attorney. Don't hold that against him. All right. He is a good guy. He's a fair golfer. Uh, I've sent clients to David because he specializes in real estate, and of course, so do we. So David's just a good guy to know, ask questions. So we thought we'd bring him on here too, and just let him talk a little bit about what investors have to watch out for from a legal standpoint when they're investing in the state of Ohio. So with that, David, I'll start just by letting you open up.
Sure. I guess I always like to open up just with a little background about myself. So, as Frank had just stated, my name is David Streeter. I am one of the members of Streeter and Petropolius. We're a small local law firm in Strongsville, Ohio. It's me and my partner, Jim Petropolius, and another partner, Sonia Siebert. And we focus primarily working with individuals and investors in real estate matters. We don't do much litigation, but I always say that I like to be my client's advisor and not the person they call when there's a problem. So, for instance, I work with a lot of investors, who own real estate already, and those folks who are just thinking about getting into real estate. We focus on setting up a good foundation for the investor to have a thriving business. And that usually, what the conversation usually starts about, the question I always get, do I need to create a business? Do I need to create a corporation or a limited liability company? And I would say, yeah, you should. Because if you're going to be treating it as a business, you should do that and have the proper vehicle in which to run your business from and to set the foundation. So, there's in 99% of the cases, in a limited liability company, it is probably the formation and the entity structure to choose. They're easy to create, they're easy to manage, they're not overly complicated, and they can be fluid as your business grows.
So David,
So,
when you're dealing with doing an LLC, one of the things that we run into is lenders don't close deals in LLCs names. How do you handle that?
yep. So it depends on the lender, but like if someone is going with conventional lending, a lot of times the lender will not close. They're going to require the investor because they're underwriting that individual investor's personal credit history as the underwriting requirements in the loan. To be honest, I've never understood why a lender could always take a personal guarantee. And you see that in the commercial space all the time. But when you're working with, a conventional lender and it's a 1 to 4 unit, building, they treat that as a residential acquisition. So most lenders, will require you to close in the name. And the thing that we find after the fact is that we can transfer it into an LLC subsequent to it. But that's always, contingent upon, the lender not having an issue with it. In my experience, most lenders, will usually acquiesce to that because what they care about is the monthly payments are made on time. And plus, by that time, they already have the investor on the hook personally. So if there's a default, the property is, or their mortgage is properly secured with the mortgage lien against the property. They have the personal guarantee of the principal, and it's not an issue. But I do say this: there is one lender out there, and it is local to Ohio, Dollar Bank. They do not allow subsequent transfer into an LLC that's owned by the investor, him or herself. So that's one thing to always consider. But there's usually a workaround, but you do have to look at those on a case by case basis.
So what are you doing? Are you taking your personal property, your personal investment property, and you're just quit claiming it over to the LLC?
Sure. And that is an exempt transfer. They don't have to pay the normal conveyance tax that you see when a deed's recorded, because at the time of filing of that deed, you can fill out what's called an affidavit of ownership that basically tells the county auditor that, hey, it's in my name right now personally. I am the member of that LLC. Here's a copy of my operating agreement that shows that I'm the member, and the county accepts that and they exempt the transfer from the conveyance.
Okay.
Which can be significant. So say the house is worth $100,000, that conveyance fee is normally $400 in Cuyahoga County, and in most counties around the state. So you can save that fee and just have to pay the recording fee for the deed.
Now, when you say, and I get this because I come from a mortgage background, but when somebody might have an issue with you transfer, in other words, like Dollar Bank, do you ask ahead of time if it's okay, or do you just do it and then hope and pray that nothing happens?
So I get this question all the time. So from the legal standpoint, I have to say that hey, you look at your loan documents and see what they state. The loan documents are going to talk about an acceleration clause. That if you default on it, which could be the transfer of the interest to an entity, it's for what's called if you transfer for a beneficial interest, for consideration, which means someone pays you money for it. You can interpret those loan documents to state that, okay, if someone's paying me for the property and I'm transferring it, that's a default. But if you're transferring it to an entity that's owned by yourself and there's no consideration and there's no transfer of beneficial interest, because the beneficial interest is I own it myself personally, but I'm transferring it to an LLC that I own. There's no transfer of beneficial interest. The ownership essentially remains the same. I don't feel that's enough to trigger the due on sale clause.
Okay, so it's the due on sale. All right.
Okay. So moving forward, people always say, well, why should I have the business entity, in the first place? Why can't I just do it in my name personally? And you can do it in your name personally. You have to remember in those instances that, you're going to be personally liable for everything that happens with that property. And you also may not reap some of the tax benefits you have. So the reasons you create an entity are for the liability protection that it gives you. Because if you open up a limited liability company and you run it as a separate going business concern and do everything you're supposed to, have separate bank accounts, don't commingle funds, and those type of things, then you're running it as a separate going business concern. And under the statutes from the state in which you operate, you're granted liability protection. The owners of that LLC can't be personally liable for the liabilities or debts of the business. So you have liability reasons that you do it. You also have certain tax considerations when you run things through the business. You have certain expenses in that you can write off that you may not be able to when you're own it in your name personally. But I always say that's where you have to have not only a good attorney on your team, on your advisory board, you need a good CPA that understands that real estate investor mindset. I'm not a tax guy per se. I know enough to be dangerous, but I would always say, hey, go talk to your accountant to figure out what the tax ramifications are. Plus, and I think this may be other than liability protection, one of the other key reasons that you want to create an LLC is that if you're an investor out there and you're buying properties and all that, you're going to brand yourself a certain way. And by having a separate, business entity for your business, you're building credibility for yourself. You're showing yourself as a business person out in the world and you're running it the right way. So it also gives you, when you approach sellers and things like that, or if you're going to approach someone who has, large portfolio that you're maybe going to acquire through a portfolio transaction. If you come in and you have a LLC set up and you're running the business the right way, I just think it gives you credibility as well. And maybe, to a seller, they say, oh, we're dealing with a business here. This is what they do. They're more likely to perform, things like that. So I always say the three reasons for, creating an entity, to run your business are the tax reasons, the liability protection, and then also from a credibility standpoint. Okay. Any questions off of that?
Yeah, I just have one about the tax, which goes back to transferring it. So if I buy a property in my own name, I can write off that interest. When I transfer it, can my LLC write off that interest?
It depends, and that's where I usually punt to the accountant.
Okay.
To be honest, I'm gonna, on that interest, in some cases you still can't because it is an interest expense.
I find it interesting a lot of times when we get these investors that call into us, they want to form a team, but really the only two people that they're looking for from us is a realtor or somebody to find me properties and then a property manager. Beyond that, they don't ask for much. And it seems as though, as an investor, you really should be looking for that all around team, somebody that can provide you with CPA, an attorney, contractors, all of that stuff. And it's unfortunate that people get into this and they just don't hire somebody at the very beginning that has that full team like we have.
Yeah, and I think that's very important. I always say, hey, you want to create your board of directors, and instead of putting them on salary and paying them, a share of the profits or something like that, you're basically hiring them when they need it. I mean, I work on an as-needed basis. I normally don't charge hourly to my clients. They call me up. If it's a quick phone call, or not only my practice, but the other attorneys in my firm, we want to answer the questions to make sure they're making good business decisions. And when there's work that needs to be done, a contract drafted, a lease written, or an eviction or something like that, we get hired on a case-by-case basis, and we flat fee 90% of what we do. And then in addition to that, the other members of your team, like you said, you got the realtor, which are, you guys there, you got the property management company to help manage that property after it's taken over. You have the CPA, you have, I'm trying to think, I have a list here. Bear with me, jumped ahead a little bit. Property management company, contractors. Get your contractors vetted and lined up before, because they're going to make or break you in the long run. I can't tell you how many phone calls I get from people where they're like, you know what, I just can't get my contractor on job. And I always say, do you have a contract? Do you have a contract, a written agreement with your contractor? Something that says what happens if there's a default, so you have something to fall back on. And those are all best practices that, I work with my clients to try to get them into that mindset of that, hey, you're running a business here and just not running a mom and pop rental shop.
So are you suggesting that they would have their own agreement that they would have signed with that contract, and not just, usually it's the work order that's signed?
Right. Yeah, you get some pushback too. Most contractors, if they're working out of their van, they're going to have that Office Max work order that they scribble down, some things, and they put a total of price at the bottom and say, here you go, sign this, our contract. If you signed it, it's a valid contract, but it doesn't have any terms and conditions in which to fall back on. And so what I do is I work with my clients to help, create customized, forms that they can use in their business. And one of them is, I call it a home renovation agreement. So if you're buying a house and you have extensive work that needs to be done, it's going to be something that you present to your contractor. Now, you are going to have some contractors that give you pushback and say, I don't do that. And to me, that's a red flag. They don't want to be legally bound. The contract I present is not overly one-sided. It basically makes it clear what the parties agreed to, and everyone signs to it. And then you can fall back on that written agreement if it goes south. And it's easily enforced if you have to go to the steps and take it to a courtroom.
Yeah, and that's pretty smart. We've seen issues in the past where people have come to us in the same situation. That their contractors walked out of the job with half the funds, and they're looking to us to help them find the right people. So, no, that's smart.
Yeah. And then, the other one that big one that popped into my head is, if you're an investor, like, Blaise, you had said that, hey, a lot of lenders won't do this, but as investors get more and more involved, you're going to see that they're going to partner with individuals. Maybe hard money lenders or individuals that have liquidity that want to get into real estate, but they don't want to manage the day-to-day. Well, those are perfect partnerships where one party can provide the funding for an acquisition, and the other one has the expertise of how to find the properties, how to purchase them, how to manage them, how to renovate them, all of that. And so, you hear the term joint venture. Well, if you do it under the terms of an LLC, it's just a two-member LLC, and that operating agreement that you draft will govern that relationship. It'll set forth, what the duties and responsibilities of the members are, who's contributing what, who's responsible for these tasks, who maybe one's going to handle the finances. We can talk about and get really creative in how to structure that investment for like the quote-unquote money partner, if that makes sense.
Absolutely.
Okay. One thing too we see is a lot of people, especially on the properties we're picking up, and we get copies of the leases. They're Office Max leases. Is that advisable? Is it?
Okay, so I was going to talk about leases and considerations about when you acquire property. Here's the thing: when you're buying a property, you have to know who's in it. Especially if you're buying it from another investor that has been renting it out, you need to understand, who is in there and what the terms are. An Office Max lease is fine. A residential lease is not overly complicated. It's pretty much governed by statute. But you do want to know what the monthly rent is, what the term is. Can't tell you how many times I get phone calls from investors that says, hey, I just closed on a property last Monday. There's a tenant in there. Just saw a copy of the lease, and it's good through July of 2024. It seems like the rents are low. Can I increase the rents? Or can I terminate this contract? And the short answer is no. When you buy a property, if there's a written lease agreement in effect, that runs with the land. So you step into the shoes of the previous owner, the landlord, subject to the terms and conditions of that lease. So how do you protect yourself, or what do you need to do on the front end before you?
Oh, I know that answer. I know that answer. You hire a good real estate agent that makes sure the leases are brought forward before we close and analyzed and made a decision on.
Absolutely. So you can see this is the lease agreement that is signed. It's funny you say that, but most people don't. They just figure, oh, I'm going to buy it, and then I'm going to kick out whoever's there. And I get phone calls all the time, because we file over 100 evictions a month, so we see a lot of them.
Wow.
And sometimes they're stuck, and sometimes you have like shady sellers. Let's use that term. I think that's a generally accepted term, shady seller. And they sign a lease agreement with someone, and the monthly rent is way below market, and you're stuck. Now, another thing to do is I've also seen, so maybe the sellers, maybe you have a great agent, like Frank here, and he goes back to the seller, the listing agent, and gets copies of leases, from the seller, but that shady seller kind of gives you the wrong leases. They kind of fabricated something on their own to make it look better, for you, and then you become the owner, and the tenant, shows up and says, no, that's not the lease I signed. This is the one I signed. Mm. And I'm going to tell you what, the court's always going to side with the tenant in this case. They're going to say, so how do you protect yourself from that? Any ideas?
Well, we and I don't know if this protects us or not, but we put together an addendum that requires seller signatures where we're requesting the current leases on the property or the leases that follow the month to month, or also the schedulees, the security deposits held, all that. So we want to see that up front as a condition of contract.
Yep, and those become seller representations that are enforceable after the fact. If the seller is lying to you, you can sue the seller for damages. But one thing that I like to do, and you see this in the commercial space more than in the 1 to 4 family residential investment space, is there's something called an estoppel certificate. An estoppel certificate is basically an acknowledgement signed by not only the seller, but by the tenant. It's a one-page form that says, hey, I'm on a 1-year written lease agreement. My lease expires on this date. This is the monthly rent that is due and owing under the terms of the lease. And that's basically it, but it's signed off by the tenant. So if the tenant comes up later with another lease that maybe they fabricated this, because they know the courts are going to side with them, you can basically stop them. That's the estoppel certificate. It becomes a stopper. They know, you signed this. This is going to govern, and the courts then will rely on that. So as an investor, I think it's very important, that you do all your due diligence up front. You're working with a good agent that's going to get you all those tax forms and the rental history and the rent rolls and all of that. But then take that one further step and put it on the seller. Make it a condition of the contract that they have to provide you with an estoppel certificate. And I can provide a form that's very easily fill in the blank, signed off by everyone. And if a seller gives you pushback and says, I'm not going to ask my tenant for this, well, that's a red flag.
Sure.
Right.
It's a red flag that someone's not being, totally honest, and maybe give you pause to, move forward. Some investors don't like it when I, say this stuff, because they're like, well, you're trying to blow up my deal. I'm like, no, I'm trying to protect you from making that phone call to me, 3 weeks after you close when you find out someone lied to you. So
is it inappropriate? Is it inappropriate as a buyer buying a property to ask if you could, maybe not on a current lease, but on a month-to-month, ask if you could pre-screen that tenant just like you would if you were putting somebody in? Could you pull credit and ask for a driver's license and things like that, like you would with a third-party site?
I don't think it's totally inappropriate. It's uncommon. I think because I think you're going to get a lot of pushback from those tenants at that point, going, well, wait a minute, why am I now being vetted again? But I do think it's appropriate, to make it known to the seller that, hey, before you close on this, you're going to do a walkthrough and you're going to knock on the door and introduce yourself to the tenant, the prospective buyer and the new landlord. And I think at that point, you can get a real good pulse on the type of tenant you're going to be inheriting.
Yeah, and I think a big pushback you get doing that, Blaise, early on is the seller doesn't want any problems where their tenant's going to move out
Right.
because you may not close on the transaction. Something could happen, and we don't close. So they're going to protect that income until they're absolutely done with that property.
Yeah, and that's true. And your purchase agreement should have terms in place that, that the seller is not going to, execute any new leases without your permission if you don't want them extending that lease term, because, an investor might, look at it and say, hey, I'm okay having this tenant for 3 months after closing, but my ultimate plans here to capture my ROI is to, flip this thing or maybe turn it into an Airbnb. You see a lot of that with the short-term rental market. There's so many, good ways you can make money, in real estate investment. You don't want to shortchange yourself and lock yourself into a long-term commitment. And if a lease does expire during the contract term, prior to closing, the understanding is that you don't execute any renewals. You just let it go month to month. So as the new buyer and the new owner, you have all the leverage to basically dictate how, that tenancy will move forward.
Those are smart clauses to put in for sure, as far as not executing the new lease in the meantime.
And one of the things, that, we can always talk about is, hey, you said you cover a lot of this through the addendum, because it's these terms and provisions aren't covered in the standard, contract that, that you're used to using. But you can then, create an addendum that kind of protects, I call it the investor addendum, that sets forth those sellers' representations and warranties and all the things that we've been discussing.
When we talk about deposits, this is one of the places that I feel is a gray area. Just maybe it's me not understanding, but we ask for the deposits to be collected at closing. It's right in the contract, and they credit that at closing. But what we don't have is we don't have proof of what that unit looked like before they started renting to them. So how do we know if the tenant gets the deposit back or not? Because we don't know if the carpets were dirty when they started off.
Right. So it depends on the seller. Is it a good landlord seller? If it does, that seller probably has records of pictures at least prior to the tenancy. If they don't, you're kind of stuck. And you're going to, the assumption is at the time you purchased the property, whatever the condition of that unit is what it was at the commencement of that lease. So unless you have real evidence that can only be provided from the seller that you're buying it from, you're going to be stuck there. One other thing, I just thought of it, like once you close on the property, what's the first thing that you need to do? Is that you need to send a welcome letter, I call it. It's basically a notice to the existing tenant that, hey, ownership has changed. I'm the new owner, I'm the new landlord, I'm the new property manager. According to my records, this is the amount of monthly rent. Also at closing, I was credited a security deposit, or perhaps I was not credited a security deposit. And then that tenant comes back to you and says, well, no, I paid a security deposit. And you say, well, I don't have it. Here's my, you can always prove it through a closing statement if you didn't get a credit. And if that's the case, then you go ahead and go back to the seller and say, what's going on? Because we have a security deposit issue here. But that welcome letter should also state, contact information, for maintenance requests, where to mail future rent payments to, kind of give your policy as far as paying rent and things of that nature. Especially, I do a lot of work in Cleveland Municipal Court, and they've recently started requiring copies of those notice letters, in order to move forward with an eviction. Because the court takes the position that, hey, if you can't prove to me that you let the tenant know where to send rent, how do I know that they're defaulting in rent because they just didn't know where to send it and they put it on you, the landlord?
Okay. So we're at about 24 minutes right now, and I can tell we're going to have to bring you back again sometime because there's just so many questions that I have.
There's so much.
But you said the key word that I've been wanting to ask the question throughout this whole thing, and that's evictions.
Yeah.
How do evictions work for out-of-state investors? Just what constitutes evicting somebody? Give us.
And what's the average time frame it takes?
Yeah, give us evictions for dummies right now.
So for instance, it depends on the court you're in. So you really have to understand. So if you're buying in the city of Cleveland, for instance, your eviction process can be totally different than if you're buying in Berea, Ohio. So as part of your due diligence, you want to know the jurisdiction you're in, and then talk to a local attorney in that jurisdiction to say, hey, what's the eviction procedure? Because I can tell you in Cleveland right now, the average eviction, if we file a new case today, say we have everything ready, we can file, we're not going to get our first hearing for 3 weeks. I know if we file in Parma, Ohio, we file today, we're going to get our hearing in 2 weeks. But it's not only that time frame anymore that really matters, it's how does the court look at these? And that's going to vary greatly on the jurisdiction unit. And I always go back to Cleveland because that's the biggest, housing court in the state of Ohio. And it, has right now, they have more requirements that they place upon landlords than any other court that I practice in. We have to prove ownership. We have to prove that the business that owns the property is in good standing with the state of Ohio. If we have a written lease agreement that we inherited that had an LLC as the landlord in there, Cleveland Municipal Court makes us print off the records from the Secretary of State to show that that's in good standing. So it's just this snowball effect, and as a landlord, it puts more of a burden on you. You have to deal with lead requirements now in Cleveland and rental registration requirements. So you really just have to know the jurisdiction that you're in. And like you said, Blaise, we could come back and talk about evictions in Cleveland as opposed to evictions in Parma, Ohio, and that could be a seminar in and of itself.
Okay. Well, how many counties do you cover, David?
We cover basically Cuyahoga County and everything that touches it. And then if you go out and everything touches it again. So Northeast Ohio, anywhere from, Youngstown to Sandusky, all the way south to Canton and Mansfield.
So pretty much the same areas we do. All right.
Yeah, we cover a pretty good area. In all of our evictions, we try to systematize our process up front. We're sticklers on having all the information that we need. We won't file it if we feel something's missing, because if something's missing, it's going to get kicked out. We're going to have to start over. So we spend a lot of time on the front end, but then once it's filed, it kind of goes into autopilot. We work with a lot of out-of-state investors, Blaise, to go to your question about how to, and the biggest part there is you're working with local property management, that's fine. What I need in every case is someone who posted a 3-day notice to show up and testify to the fact that they posted that. The court requires that. So if you have an investor in California that's not posting the notices, they got to get someone here locally to post that notice. And there are services out there for people who post and then show up at court to testify to that effect. And that's something that we can always make that introduction to these out-of-state investors.
Sounds like a good side gig.
Yeah, a little part-time job.
Yeah.
$100 a pop.
Yeah, it depends on where it's at, I guess. That could be a really tough job too if you're going into some place.
Wear your bulletproof vest, babe.
Yeah.
All right. Well, we are right at about 30 minutes. So, David, we truly appreciate you. If you're not already a member of our page that we have on Facebook, we'll send you a link so you can jump on there and make comments as well. Yeah, I got your business card right here, so I'm going to go ahead and just in the chat underneath of the live video, put all of your contact information in, because we have about 180 people on the page already, and they can reach out to you if they have questions, knowing that you're part of our team of what we try to refer out and who we help. So again, thank you.
Before we let David go, I just got to mention something about your business card, David. Guys that are as old as Blaise and maybe me and Scott, we can't read this, man. Your print is so small on it.
I know. We're working on that on the next batch. You're not the first one to tell us this. You know what's funny, though? Let's talk about business cards. I got a copy of Blaise's business card, and there was a picture of him there. I didn't even recognize him.
I rented a suit for that picture. I don't even own a suit.
No beard, suit, his high school diploma still in his hands. I know.
Yeah.
Nice. All right, guys. I appreciate all of you, and I'm going to go ahead and end the live.
All right, thanks.